Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 158. We have, of course, three cases. The first relates to the issue of protected discussions and the admissibility of evidence and the extent to which that is limited under Section 111A of the Employment Rights Act 1996. The second relates to a case on whether or not the tribunal was entitled to infer that there was a racial element to the employer's decision-making process. And the third, it's a follow-up on a case that we've looked at previously, Gray and Marberry, as to the outer limits of what amounts to a philosophical belief that is protected by law. Please don't forget podcasts available via iTunes, Mayor Brown website, YouTube, Twitter feed under Nicholas ROBER11, and we have links to the cases as well posted out on Twitter, and we're on Spotify, Google Play, Yahoo, etc., etc. So, first up, Harrison and Arimin Limited. This case relates to Section 111A of the Employment Rights Act 1996 and the circumstances in which offers to settle a case are excluded from being admissible in evidence. Imagine a situation, the employee wants to say, my employer wanted to get rid of me and made me an offer to settle. Well, the government introduced legislation designed to facilitate the ability to have discussions off the record, but it's strictly limited. So, Section 111A is entitled Confidentiality of Negotiations Before Termination of Employment, unquote. And it provides that evidence of pre-termination negotiations is inadmissible in relation to unfair dismissal claims. Pre-termination negotiations mean any offer made or discussions held before the termination of employment with a view to that employment being terminated on terms to be agreed between the employer and employee. It does not apply in circumstances where the complainant, according to the complainant's case, is asserting that he or she has been automatically unfairly dismissed. That's Section 111A(3). There's another exception, Section 111A(4), which says the tribunal can permit evidence to be included in the case if it is just to do so, where anything said or done was improper or was connected with improper behaviour. In those circumstances, as I say, the tribunal can choose what to admit and what to exclude about those pre-termination negotiations. So in essence, the situation is the employer can make an offer under Section 111A to suggest or propose the termination of employment. That would generally be inadmissible only in relation to unfair dismissal claims, but not in relation to claims where the dismissal would be automatically unfair, and not if anything was said or done which, in the tribunal's opinion, was improper behaviour by the employer or connected with improper behaviour. In those circumstances, the employer's settlement approach is potentially disclosable. In this case, there's quite a tangled web in the proceedings because it appears that at one point, and for entirely understandable reasons, the tribunal judge did not understand part of the claimant's case. But in essence, the claimant brought a claim, having worked for the employer for 13 years, asserting that she'd been unfairly dismissed, partly on the basis of constructive dismissal, and that she'd been discriminated against on the grounds of pregnancy or maternity or sex. The claim asserted further that the managing director of the employer, in a letter of 15th August 2016, had made it clear to the claimant that he intended to bring the working relationship with her to an end. The claimant's case was that was the final straw after a series of incidents over the previous few years, all connected with her decision to start a family. The respondents, grounds of resistance, asserted that the letter of 15th August 2016 was inadmissible by virtue of Section 111A. Furthermore, it went on to assert that, to the extent that the claimant was claiming discrimination, there had been no improper behaviour, and therefore she could not rely on it in her discrimination claim either. Now, obviously that part is wrong because Section 111A only applies to unfair dismissal claims. It does not apply to discrimination matters. Well, there were a couple of preliminary hearings And then the Employment Tribunal concluded at the second preliminary hearing that in relation to the unfair dismissal claim, the letter was excluded by virtue of section 111A. The claimant appealed to the Employment Appeal Tribunal, which allowed her appeal. Her case was that the judge had failed to consider section 111A3, i.e. her case was that she'd been automatically unfairly dismissed, and secondly, her case was that there had been improper behaviour by the employer, i.e. she was saying that section 111A4 applied, and that too was a route by which the letter could be admitted into evidence. The EAT gave a useful review of the law in this area, and they pointed out that there's an ACAS code of practice on settlement agreements which ACAS have produced. A failure to follow the ACAS code does not give rise to any liability by itself, but tribunals should take it into account in deciding issues. In the context of whether or not behaviour is improper, the code indicates that this is a wider test than one for admitting without prejudice correspondence, where generally without prejudice correspondence is out of bounds unless there has been unambiguous impropriety. And this approach, the ACAS code approach, is supported in subsequent case law. Now, one of the things that would amount to improper behaviour, according to the code, would be acts of unlawful discrimination. The EAT then went on to make what I think is an important point. Under section 111A, there is a difference in approach between the two ways in which, in this case, the settlement letter could be introduced into evidence. First, if the claimant's case that is being asserted is that there has been an automatic unfair dismissal, then the settlement letter is available to be considered by the tribunal. As the EAT put it, section 111A3 applies wherever the claimant puts his or her case in a certain way, regardless of whether that case is ultimately upheld. In those circumstances, it will be necessary for the tribunal, in deciding whether to admit the case under section 111A3, to work out what is the claimant's case. However, under section 111A4, the improper behaviour exception, the tribunal has to go further. The tribunal has to form an opinion or make a finding that there has been improper behaviour, and then the tribunal has to go on to consider whether it is just and equitable for that to effectively override the application of section 111A itself. Here, properly analysed, the claimant's case did include a claim under section 111A3. Equally, the case was very similar for the claimant under section 111A4, i.e. she was claiming there had been improper behaviour because she was discriminated against. All of this, I have to say, tends to reinforce my view that section 111A is a pretty limited benefit to employers. The ease with which a claimant can sidestep the protection of section 111A means that an employer can have very little confidence that a settlement offer made under cover of section 111A will remain under that cover. Equally, as is well known, the problem for many employers is that at the point at which they wish to make the first approach, it's often very difficult for without prejudice label to be truly applicable, because there's often at that point no dispute. So it's very difficult to position the approach as being truly without prejudice without that necessary dispute in existence. So what's the alternative? Imagine a situation where the employer wants to talk to an employee, the employee hasn't threatened proceedings or anything of that nature, but the employer wants to suggest to the employee that it might be time for the employee to move on. Well, I think one alternative is to be more upfront about things. If the employer wishes to approach an employee to talk about a potential departure, then I think it is unlikely that a tribunal will, by itself, view an approach as manifestly inappropriate. Clearly, the employer needs to make it apparent to the employee that there's no pressure on the employee to agree to enter into any discussions, and there will be no sanctions if the employee chooses not to. But on the basis that parties are generally expected to try and resolve matters by agreement rather than involve a tribunal, I think it would be an unlikely set of affairs that would see an employer penalised for asking, in an appropriate manner, whether an employee wished to have a without prejudice discussion. I also have to say that my overwhelming experience is that once parties have agreed to have a without prejudice discussion, it's pretty unusual for one party to turn around and say, yes, I know I agreed to go into this willingly, but I've decided it was not without prejudice at all. In any event, the answer to that, of course, is to ensure that nothing is said or done during the without prejudice discussions that would harm the employer if the discussions are not properly without prejudice. In many circumstances, that means that the employer needs to be very careful about choosing its words as to what will happen if the employee does not take the suggested settlement on offer. But apart from that, I do think that the route, the section 111A route, is very unlikely to be a useful cloak if an employer wants to be direct with the employee, because it is so easily sidestepped. So that's Harrison and Arimin Limited. Next up, Base Childrenswear Limited and Otshudi. This is a Court of Appeal case where the issue is the extent to which the Employment Tribunal has been entitled to find in the claimant's favour in relation to her claim for race discrimination. The claimant is a black African ethnicity from the Democratic Republic of Congo. Her claim for unlawful racial harassment was upheld by the Employment Tribunal, and this is what was being appealed to the Court of Appeal. The background was that the respondent's business is selling children's wear, and the claimant worked for them as a photographer. She was told in May 2016 by the managing director that she was being dismissed for redundancy. This came completely out of the blue, and the claimant reacted, telling them that she thought this was a further instance of her being a victim of discrimination. The managing director reacted very hostilely to this, according to the evidence, and this included daring her to repeat the allegation. She was then asked to collect her belongings and leave, and the grievance that she submitted subsequently was simply ignored by the employer. Some 15 months later, with the tribunal case only 3 weeks away from a full hearing, the respondent changed their story. They said that 2 employees had found 5 items of designer clothing concealed in the photography department. The claimant was then seen taking the clothes back, it was alleged, to the stockroom. The managing director and the others took the view that the claimant had been responsible for taking the clothes from the stockroom with a view to stealing them. The respondents decided that she was guilty of theft and that she would be asked to leave immediately. But, they said, they took the view that it was better to tell it was redundancy to minimise any potential confrontation. It was denied that race played any part in this decision. Oddly, by the time the case has got to the tribunal hearing, it's become a case on racial harassment rather than direct unlawful racial discrimination. But in the end, nothing turned on that. The dismissal case could be framed as racial harassment. But the claimant was saying that the decision to dismiss her was tainted by unlawful racial discrimination. That's the key point. The case, to a large extent, seems to have turned on the burden of proof in discrimination cases. Section 136 of the Equality Act 2010 says that if there are facts from which the court could decide in the absence of any other explanation that person A contravened the prohibition on discrimination, the court must hold that contravention occurred. That does not apply if A shows that A did not contravene the provision. This, of course, has been the subject of much case law, and the leading case is Marberry in the Court of Appeal, which decided it was not enough to prove the possibility of discrimination from the facts that had been demonstrated. It needed to be that the tribunal could conclude on the balance of probabilities that unlawful discrimination had occurred. Therefore, merely saying there's a difference in status and a difference in treatment between 2 comparable employees is insufficient to draw a conclusion on discrimination on the balance of probability, because merely having a difference in status and treatment would indicate the possibility of discrimination. Something more is required before the burden shifts. If the tribunal has satisfied that the claimant has proved facts from which a reasonable tribunal could properly conclude that discrimination occurred, then the burden shifts to the respondent to prove that it did not. So how did that play out on these facts? Well, the Employment Tribunal decided the burden of proof did shift to the respondent because of the strong and intimidatory reaction to the claimant's original allegation of discrimination. This was also in circumstances where the managing director had given an admittedly false reason for the dismissal to the claimant. The refusal to address the claimant's grievance also supported an inference of discrimination. The persistence in advancing a false reason for the dismissal to the tribunal, even though the asserted reason for the original lie, i.e. to avoid confrontation, no longer applied because there was a tribunal proceeding underway, also counted heavily. On that basis, tribunal found the burden of proof had shifted to the respondent, who then failed to prove that race had played no part in the decision making. The respondent's appeal was based on 2 arguments. First, the respondent said there was no evidential burden for the tribunal accepting that the facts that had been proved would allow them to draw inferences of discrimination. In other words, it was saying the claimant had not shown enough facts for their to shift the evidential burden. Secondly, the respondent pointed out that the tribunal had not decided that the managing director had made up the story about stealing. Therefore, they had not addressed the argument that if the respondent genuinely believed that the claimant was stealing, well, that was a non-discriminatory reason for the dismissal, however mistaken it was. The Court of Appeal said the issue was whether the tribunal could be satisfied the claimant had proven facts that would justify a conclusion that the claimant's race was a factor in her dismissal, in the absence of a satisfactory explanation from the employer. That would be sufficient to shift the burden of proof. The Court of Appeal expressly acknowledged they would not have gone as far as the tribunal, and so the implication is that they would not have accepted that the burden of proof shifted. However, since this was a question of fact, not of law, the tribunal's decision was one which the Court of Appeal felt the Employment Tribunal could legitimately come to. Therefore, the Court of Appeal did not interfere. The key fact was that the managing director persisted in lying about the reason for the dismissal long after there was any useful purpose to do so. Giving a wholly untruthful response to an allegation of discrimination is well recognised as the kind of conduct that may indicate the allegation is well founded, the court said. Clearly the court felt this was very close to the borderline, but ultimately accepted the tribunal could come to the conclusion it did. Secondly, the court accepted that the Employment Tribunal had not found that the story about theft had been made up. However, properly analysed, the court felt that the managing director's willingness to believe that the claimant was stealing was influenced by the claimant's race. They pointed out there was no investigation by the employer, and the employer had jumped to the conclusion that the claimant was stealing, despite the flimsiness of the evidence. So, on that basis, the claimant won her case. Well, I wanted to go through this for several reasons. First, I think it's a useful indication of how the burden of proof works in practice. It shows also that an unduly aggressive response to allegations of discrimination rarely plays well. Here, the intimidatory response, as the Employment Tribunal characterised it, counted heavily against the employer. Thirdly, of course, the tribunal seemed to be saying that they might have had less concern about the respondent's change of story if the defence lodged to the original claim had made clear the full picture. The Court of Appeal were a bit more understanding that having embarked on a particular explanation, maybe the employer felt the need to carry on with it for longer than the Employment Tribunal would have thought appropriate. But it's a pretty good indication that the parties need to get their thinking in order before the defence is lodged in order to avoid this sort of adverse conclusion. Underneath it all, of course, is the recognition that giving a completely false reason to an employee for a dismissal is unlikely to be successful, particularly if the employee has been made redundant with no process and in circumstances where there was no need for redundancy. So that's the case of Base, Childrenswear and Otshudi. So then, third and final case, Gray and Marberry Company Design Limited. We've dealt with this case in an earlier podcast, but I thought it was useful to pick it up again, given the Court of Appeal have now had an opportunity to look at the case. Basic facts were that in January 2015, the claimant started work for Marberry. She was asked to sign a contract of employment which had a standard copyright clause in it and a copyright agreement. She signed the contract of employment, but not the confidentiality agreement, because she felt it was far too wide and would affect matters that were her own creations relating to working, artistic and creative output. There appear to have been a number of discussions. Marberry offered an amended form of the copyright agreement which only applied to Marberry's business or matters arising for her employment. This wasn't good enough for the claimant, and eventually the offer of an amended copyright agreement was withdrawn. She was asked to sign the original one, she refused, she was therefore dismissed. She started a tribunal claim, and eventually this was amended to be a claim under the Equality Act 2010, saying that she had a belief about the rights of individuals to own and profit from and receive credit for their own work. Now, she therefore claimed that this was effectively a philosophical belief that was worthy of protection and is protected under the Equality Act, and that she was treated adversely because of her philosophical belief. Well, there's no definition of philosophical belief in the Equality Act, but there is a Code of Practice of Employment 2011, which gives some guidance on the meaning of religion and belief for the purpose of the Equality Act 2010. A relevant belief is not limited to faith or worship of a god or gods. It must affect how a person lives his or her life or perceives the world. It must be genuinely held. It must be a belief, not an opinion or viewpoint based on the present state of information available. It must be a belief as to a weighty and substantial aspect of human life and behaviour, and this is the critical one for our purposes, the human life and behaviour point, it must also attain a cogent level of cogency, seriousness, cohesion and importance. It must also be worthy of respect in a democratic society. Well, the Employment Tribunal pointed out that the claimant, whatever her beliefs are in relation to owning her own creative and artistic endeavours, never made her views clear on this point to the employer. By simply refusing to sign the agreement, this was not a manifestation of her beliefs, so as to identify those beliefs to her employer. The employer went on to say that whilst they did not deny the philosophical theories that underpinned the claimant's belief, they did not accept that a person who agreed with the notion of that copyright theft was a bad thing would necessarily hold a belief which carried a sufficient level of cogency and cohesion to qualify as a belief to be protected under the Act. The claimant was not holding that belief as any sort of philosophical touchstone to her life. The claimant had brought a claim for direct and indirect discrimination. The direct discrimination claim was rejected because she was dismissed for not signing the copyright agreement. She was not dismissed for her philosophical beliefs, which the respondent had no understanding or knowledge of, and the Employment Tribunal had found that anyone refusing to sign the copyright agreement would have been treated in the same way. And there was no appeal against that part of the Employment Tribunal's decision to reject the direct discrimination claim. It was the appeal against the claim for indirect discrimination which went up to the Court of Appeal. This claim too was rejected by the Employment Tribunal, and they found that the respondent's provision, criterion or practice would have been justified. The Court of Appeal rejected all three grounds that were brought up before them for appeal by the claimant. First, the Court of Appeal took the view that there was no causal link between the philosophical belief and the dismissal. The Court said the claimant was dismissed because she did not agree to wording in the agreement and that she felt it was too favourable to the employer. A debate or a dispute about the wording or interpretation of an agreement was not a philosophical belief within the meaning of Section 10. On that basis, the appeal failed. Secondly, the claimant's case on indirect discrimination also failed because there was no evidence that it would have been a disproportionate disadvantage to people who shared the claimant's views on copyright. According to the Court of Appeal, the claimant's crisis of conscience about signing was not the result of her belief, but the result of her wish to achieve a greater protection for her own creative works. Finally, the claimant argued that because the employer had offered a compromise copyright agreement to meet some of her concerns, although she said this was unsatisfactory too, this meant that when she was dismissed based on the original agreement, because the compromise agreement offer was withdrawn, that dismissal must have been unjustified. The Court of Appeal described this argument as ingenious but singularly unattractive. It was sufficient to find that the provisions of the agreement in its original form were reasonable. The fact that the employer tried to accommodate the claimant's concerns, the court said, albeit it did so in vain, did not undercut the employer's reliance on the original, unamended document. I confess having a little bit more sympathy than the court did with the final point. After all, my recollection of the British Airways case, Owida, was that one of the reasons British Airways lost was that after the claim had been brought in the courts, but before it had been decided, British Airways had changed their dress code policy so that the offending crucifix would no longer have been offensive. Anyway, the Court of Appeal here did not agree, and that clearly carries rather more weight than my views. I think the case is a useful one. The court's careful analysis of the reason for the individual's dismissal, differentiating it from the claimant's philosophical belief, is helpful. And it shows that without a rigorous process of analysis, it's possible to conflate someone's objection to doing something with the underlying philosophical belief. So, thank you very much indeed for listening to podcast number 158. If you've not done so yet, do go back and have a listen to the last podcast episode, number 157, which is an introduction to German employment law in the form of a discussion with my colleague Pauline Moritz. It is well worth a listen. And apart from that, I think it just remains to say that no employees were harmed or mistreated in any way in the making of this podcast. Thanks so much for listening.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.